On the East Coast, and good morning to everyone else. Thank you so much for joining us for today's webinar, Texas SB 140 Explained. I'm David Carter. I serve as President and CEO of the Ecommerce Innovation Alliance, as well as the Head of Litigation and Regulatory Policy for Postscript. I'm joined today by Alexis Buese, a good friend and collaborator. Alexis, would you like to take a moment and introduce yourself?
Sure, absolutely. First of all, I just want to say thank you so much for having me. I appreciate the invite. I am a litigator in our Tampa office of Bradley. I primarily practice in the defense of consumer class action with a particular emphasis on telecommunication laws such as the TCPA, the FTSA, and other state privacy laws. So I'm honored to be here and thanks for including me.
Great. Well, thanks for joining us, Alexis. Just a couple housekeeping matters as we get things started. First, today's presentation is being recorded. There are, in the engagement panel on the right side of the screen, you should see both a chat feature as well as a Q&A feature. If you have questions, please enter them into the Q&A feature. We will do our best to try to address those if time permits, but we do have quite a bit of content to cover today. So anything that we can't address during the webinar, we'll try to do as follow-up questions after the webinar. Please do keep in mind, as I said, because the session is recorded, don't include any private or personal information in the chat or Q&A that includes private information about the company that you work with, things of that nature that you would not want to be shared publicly, as this is not a protected attorney-client communication. As we get started today, I wanted to, again, give a brief disclaimer that the webinar is not intended to constitute legal advice for you or your business, and that we do recommend that your business consult with qualified legal counsel if you need specific guidance. So with that, let me dive into a quick overview of SB 140. SB 140 amends existing Texas law to add text messaging to some of the definitions and chapters related to telemarketing. And as we go through this, it'll be really important to understand the changes that it does make, as well as the changes it does not make. And so we'll try to highlight where the law actually has implications and where things remain as they were. The law is set to take effect on September 1st, 2025. So it has a very brief implementation period, and we understand that therefore, a number of companies and customers are looking for specific guidance about how the law impacts them in this window of time. Ultimately, this bill, SB 140, amends 3 specific chapters of the Texas Business and Commerce Code. Those are chapters 302, 304, and 305. And we'll talk about each of those here. I think an important starting point, though, to understand this legislation is that the bill was put forth and adopted unanimously by both chambers of the Texas legislature based on a series of representations that I think are important to understanding the intent of the bill. The author of the bill spoke specifically about how Chapter 302 of the law did not include text messaging, and that as a result of that, he felt that people were subject to, in Texas, receiving unauthorized text messages, not being adequately protected against unauthorized calls or unauthorized text messages, and telling his colleagues that if you vote for the bill, it will be to help protect your constituents from these unwanted calls and texts. This was echoed on the House side of the legislature as well, where the key sponsor on the House again reiterated and told individuals that the purpose of making these changes was to help Texas consumers be guarded against unwanted text messages. And so let's look at how they did and whether they actually accomplished their objectives.
And David, if I could just for a second, I think it's one of the most interesting things is, I was involved in amending the FTSA in Florida. And, when legislatures get this idea that they're going to stop, spam text messages, I think everyone is thinking back to those auto warranty calls that people used to get a couple years ago. And, they're not really focused on the fact that these thousands of text messages are actually customers 99% of the time who've signed up for a service, have double opted in, and all they need to do is press stop if they don't want to receive text. So sometimes they're trying to balance, the fear of unwanted text versus the reality of what's actually happening. And I
Yeah.
think that's where we ended up here.
Yeah, I think that's absolutely right, Alexis. I think maybe a current example a lot of people are experiencing are for those that have easy pass tolls and they're getting messages saying that your toll has not been paid and you need to, click a link to pay for those tolls that you never actually incurred, and the scams that are associated with that. And as we've gone around the country in a number of different states to talk to legislators, who either put forth the legislation that's causing some of these unintended consequences or trying to stop them from adopting legislation that's having unintended consequences. Very few are really clear about those distinctions about sort of how the industry operates, how most of the businesses throughout the country that are relying on consent, it's consumers who want to receive these messages, and they're not necessarily thinking again about how to provide the clarity that the bill is only intended to reach those that are unwanted. And so that definitely appears to be the case here. When this legislation was introduced earlier this year, it was a single line of legislation, and it just simply said the definitions in chapter 304, which we'll talk about, will apply to chapter 302. And it didn't differentiate or explain what the implication of that was, or what the intent was. So no one showed up to testify about the legislation. No one was tracking it. Kind of sailed through both chambers without really having clarity on the intent and the ramifications of the law. And so as a result of that, no one was able to educate these particular sponsors of the bill about what some of these unintended consequences would be. So let me talk about one issue, and then I'm going to hand it over to you, Alexis, to talk a little bit more about the other chapters. But a number of people have asked questions about the Texas, what we refer to as quiet hours. And these questions, I think, are arising largely because there has been a huge uptick in frivolous quiet hour litigation over the past 9 to 10 months. And so brands are rightfully kind of concerned about whether this will be another opportunity to get trapped in quiet hour litigation. Texas law has included quiet hours for many years. And those quiet hours are somewhat unique because not only do they restrict calls between the hours of 9 a.m. and 9 p.m. is when you can call during the week, which is a little bit less than what you can under the federal quiet hour requirements. But it also says you can't make any phone calls on before noon on Sunday. So that's unique in the country. I'm not aware of any other state that has specific calls out to try to stop messaging or phone calls between the morning hours on Sunday. But importantly, this bill, SB 140, does not amend Chapter 301. So Chapter 301 is not touched by, doesn't get added to the list of things where text messaging is relevant. And indeed, Chapter 301 is pretty clear that its application is to unsolicited calls made to residential telephone numbers. So our view on quiet hours in Texas is that as a matter of an interpretation of the statute, this quiet hour provision is not applicable to companies who are sending text messages with prior consent. Nevertheless, because of the amount of litigation that is happening in the space, and just as a way to be proactive, I know that platforms like Postscript are helping customers put in options to honor quiet hours, even if they're not legally required to. Many platforms already have similar types of features for other states where there's a little bit of a deviation from the federal standard. And nearly every platform helps customers try to honor quiet hours as a courtesy to consumers who have opted in, even though it's not a legal requirement to do so. So for those that are wondering, again, recap, SB 140 doesn't change quiet hours in Texas. It continues to be applicable to telephone calls made without prior consent. So let's look at what SB 140 does do, and I'll hand it over to you, Alexis, to kind of talk through this first chapter.
Sure. So one of the unique changes, and I think something that has kind of grabbed the attention of a lot of businesses out there and people that I've spoke with, is the registration requirement for any business making a telephone solicitation to a resident of Texas. And then it has some really onerous disclosure requirements that need to be made as part of that solicitation. It adds SB 140, adds including a transmission of a text or graphic message of an image, and extends these requirements clearly to text message unless an exception in Chapter 302 applies. There is a host of exceptions, and I think what we're grappling with here is what applies what exceptions apply to businesses, and that's something we're digging in with the E-commerce Innovation Alliance. But in the meantime, the registration requirement does have what's a $10,000 registration requirement that you can post by bond or some other way. And then it has a whole list of things I think we're going to get into that it requires you to go ahead and do. So the registration, I think I said it was onerous. I think that's putting it mildly. It requires a whole host of things. And some of these things existed before, but it didn't exist at the level that is relevant here because it applied to telephone solicitations. It did not extend it to text messages. And so typically, and David and I have talked about this before, is a telephone solicitation is a different kind of beast than a text message. You're reaching typically less people. You're maybe offering only one product or service. For example, I tend to think of mortgage lenders, right? You applied for a loan or your credit got run and you get a whole host of telephone calls, but they're all based on the same topic. Somebody's offering you, a better mortgage rate. Text messages are different, right? Text messages by nature, you might be selling on your website a whole variety of things, maybe not, just widgets, but you're selling gadgets, gizmos, and whatever else. And so the problem with this onerous requirement is that you need to, have the officer's names, address, date of birth, criminal history, governing documents, street addresses, telephone numbers, rules and deals for promotion, suppliers of products not directly manufactured, including warehouse information, contact details. David, I think I even saw in there that it wanted to know the price that you purchased it at if you were selling it at a different price. And then that needed to be updated on a quarterly basis.
That's right.
Which is just wild. So while the 10,000 fee, registration fee is one thing, I think the registration process in of itself is a whole nother beast.
I think that's absolutely right, Alexis. Like the amount of detail that is required, as you said, if it's one product and you're sort of focusing on that on a telephone call, it still is burdensome, but it's not nearly as burdensome as you would get if you start to think about everything that could get promoted over the course of, the year through text messaging, where it could be multiple products and services that are being provided. And so there's really no proportionality that was considered when the legislature extended these registration requirements to text messaging.
I think that's right. And so we went through some of this, but in addition, a business must have a registered agent in the state of Texas to accept service. That one it's a pain, but it is, if you already have a registered agent, they should have an office in Texas. I think that's a good business practice. Anyway, you can agree to the appointment of the Texas Secretary of State. You have a filing fee, and then you can pay the $10,000, through a telemarketing bond, a certificate of deposit, or an irrevocable letter of credit. But the quarterly updates for all salespersons who are soliciting, that's obviously a little bit. I won't say a little. That's a lot of a burden. Especially if you have turnover with staff, if you've got, people placing calls. And frankly, and David, you might be better positioned to answer this than me. I'm not even sure if you're in a text messaging campaign, whether you actually have salespeople or whether it's some other marketing function and how that kind of reporting would work.
Yeah, I think there's a whole host of questions about what is really encompassed in that. And it would potentially depend on each person's business practice. Like, so maybe there's one person or two or three people that are involved in setting up the campaigns that go out. But then do you have people who answer incoming text messages and respond to address help questions that come in that way.
Yeah.
So those lines are very blurry, and it's, again, I think you can appreciate when the law was first adopted, and what people have in their head is like a call center where you hire employees and they sit in front of a desk and like make the same robocalls essentially all the time. Like, this is a very different world than the legislation was intended when you're talking about text messaging. And the legislators just didn't even start to try to address or think about those consequences.
Yeah, I think that's right. And then obviously it renews every year, and you have to post the information of the business, which again, I'm not sure how you would post if you are e-commerce only. So,
Yeah, potentially you'd have to, have a separate web page with these types of
yeah, disclosures.
information posted or
Yeah,
something like that. Again, kind of reiterating the burden that this law would apply if it applies to companies who are getting consent, which we'll talk about whether it does or not, but it would be a pretty burdensome approach. And in addition to kind of getting the registration, then once you've registered, then you're also accepting that Chapter 302 applies to the business, so to speak. So, like, if you go through the registration process, then you have already kind of acknowledged your view that Chapter 302 applies, and therefore would have to comply with the other requirements of Chapter 302, which includes, again, requirements that just don't make sense in practice for text messaging. So, one of the examples of the types of disclosures you would have to include in text messaging would be the complete street address of the location where the person is calling from. But like, for a lot of e-commerce businesses, their street address isn't necessarily um, the same. Like, people could be in multiple different locations, and if you have multiple different people that are involved in crafting the text message campaign, which street address do you
yeah,
actually produce, right? As well as the complete address of the principal location. So, if this is not the address where the salesperson is located, you potentially would, if you really went by the letter of the law, have to put multiple addresses in your text messaging campaigns.
yeah.
Um,
Doesn't make a lot of sense. I think presumably it was meant to crack down, I guess, on call centers, off um, shore, but
right.
the practical reality when dealing with text messages is this just doesn't apply.
Yeah, and then as we talked, like, before, about if you're offering a product below what you're usually charging, which is almost always the case. If you're promoting the product, you can offer a discount. Then the law wants you to put in the name of the manufacturer. So if you don't manufacture it yourself, you'd have these other disclosure requirements. In other words, if you sort of think about this holistically, right? Then once a brand or a business kind of goes down the path of saying, I want to register to be safe, then they are potentially subject to all these other requirements that are almost impossible to comply with in practice in a text messaging business, in a text messaging campaign. And then they are potentially subject to litigation if they don't comply with each and every one of these disclosure requirements. And we've seen that in other states where there were similar disclosure requirements. Virginia is a good example, where we went back to the Virginia legislature and told them and really walked them through the unintended consequences their law was creating. And they changed this to make it clear that these disclosures only needed to apply to actual telephone calls, and they didn't need to apply to text messages, because then people started to realize how ridiculous it would be if you try to pack all of this into a text messaging campaign.
Yeah.
But for companies that choose to register, they're kind of putting themselves potentially in this weird area where, if they don't then check all the boxes, a plaintiff could come and use that as a reason to bring litigation against them.
And David, are you thinking that in the text message itself, it needs to have the street address and location? Or are we thinking this is, you know, I how many texts would it take essentially to complete this information? You're already dealing with a character limitation, right? Like,
That Yeah, that's right. I think that's a really, like, unknown question, because the way that the telephone the way that the legislation is read, if I recall correctly, is like, this information must be disclosed in the solicitation.
yeah,
And when you're on a phone call, you can address that either through a recording or have a script or something like that. But when you're talking about text messaging, like I think there's a serious question about, is every text message you send a new solicitation such that each of these disclosures has to be included each time you send the text message? Again, it's completely kind of impractical if you try to implement this in practice.
I completely agree. I am not sure how this would be achieved, and I think, frankly, the plaintiff's bar is going to enjoy trying to, go after everyone who isn't following what they deem the letter of the law.
Yeah. So let's talk about some of these exceptions, right? And I think that this is, to me, is really the meat of the issue here are these exceptions. So there's two, and I'll let you take the first one here, Alexis.
Sure. I think the big one, and the one that I would argue would apply to everyone that's using, any kind of double opt-in procedure, is the customer exception. And so this is an exception, or an exemption, I should say, that says a former or current customer doesn't, if you're texting a former or soliciting a former or current customer, then, and excuse me, you have to have operated under the same business name for at least 2 years, then this registration requirement does not apply. And I would argue that the definition of customer really encompasses somebody who is on your website, who has perused your, goods, essentially, opted in to receive your text messaging campaign, and confirmed that they want to continue to receive text messages. And obviously, if somebody pressed stop, or whatever other opt-out mechanism you have, that person then presumably is a former customer, although good text messaging practices would require you to stop texting them anyway under the TCPA or other relevant, state law analogs. I think, again, this is not legal advice. I'm not providing legal advice, but I would say that given the exemption for customer, that the only way to really read it is that anyone who has a solid double opt-in doesn't need to comply with the registration requirement. Although I would heavily caveat that by saying, obviously, this has not been tested. And David, as you know, there is no definition of customer in the statute itself, which makes it very vague and open to multiple interpretations.
Yeah, that's right. So it's unusual, so to speak, that in this statute there is a definition for the word purchaser, but that they chose not to use the defined term and instead use a different word, customer, for this exception. And what I think is also super interesting is that the defined term purchaser does not actually require a purchase. And so the definition of purchaser is broader than what you would logically think it would, which it includes those that are soliciting to become a potential purchaser. And so there we have, I think an intent is clear that even the word purchaser is broader than what most people would think of it would be. I think that lends it some credence to the idea that therefore a customer certainly shouldn't be more narrow than the word purchaser, right? And so I think that helps to bolster a conclusion that customers, if we just think about how people use the word customer in everyday parlance, right? Certainly someone that comes in and buy a product from your store is a purchaser. But, tell me someone who would not say to a colleague when someone just comes in and they're browsing before they've made a purchase, hey, can you go help that customer, right? Like people use that all the time to refer to someone who is browsing or potentially shopping. And I think therefore that there's a really strong sort of argument to be made again in a court that of course customer has to be broad enough to include those who are browsing. And particularly in this context, we're not just talking about those who are casually browsing. We're talking about those who have provided their consent, asked
Right.
to receive these messages. So it's like there, we don't have to slice and dice too much of the definition of customer. These are people who have clearly engaged in sort of a level of a transaction with the shop. It just didn't result in the exchange of currency yet, but it is leading to that place, right? And I think therefore there's a lot of signals that a court should look to say, yeah, we're not going to define customer so narrowly to exclude those who have asked for consent.
And another good point to think about too, David, is this is really thinking about how your mechanisms for opting customers in, right? And making sure that you have clean opt-ins, clean records, so that you can show, these are people who have opted in, who are customers. You're not just, and I know PostScript doesn't do that, but you're not sending text messages after people haven't responded, haven't done whatever. And when you look at the legislative history, it's clear that they were focused on unsolicited and spam, scam messages. I don't think anyone wants to stop getting, and the examples I've used before is nobody wants to stop getting messages that they've signed up for. Like, I don't want to, not get my FedEx package notice delivery now. I don't want to not, I'm waiting right now actually for a text message. I got a flat tire this morning. I would like to know that my car is ready for
How much
pickup.
is that going to cost you, right? That's what
Yeah.
you really want to know.
Exactly. Right. Are you saying if I'm in Texas, I don't want to get, yeah. So I don't think that is what the legislator meant. And so I think that we have a robust argument in terms of that was the intention. And especially when you look at the language of the two folks that you put up earlier, who were the sponsors of the bill.
Great. So let's talk about the second exception that I think could also fairly encompass, again, those that have visited the website, put their number in the pop-up, said, I want to receive your messages. And this is the retail establishment exception. This also applies if you've been in business for 2 years. And so I think important just to call out really clearly, both of the exceptions that we're talking about have this 2-year requirement. This 2-year requirement, I think, makes sense if the concern is, and we've seen this happen like with bad actors, where you like pop up a business, spam a bunch of people, close the business down, go somewhere else on another platform, spam a bunch of people, sell a few things, close the business down. And so I think that, like logically, this 2-year limitation is trying to protect from fly-by-night operations. They want you to have an existence where you can actually find the people who are sending you the messages and they don't disappear in the middle of the night. So if you're brand new, you probably have to really be thinking hard about the registration process. But let's talk then just kind of that piece aside. You've been in business for 2 years. And then this exception is pretty broad, right? If you've operated under the same name,
Yeah.
And it's a name, and you've had a retail establishment where consumer goods are displayed and offered for sale continuously. So you're not opening and closing your shop, right? And the majority of the business involves buyers obtaining services or products at the retail establishment. And then the question is, like, what does the word establishment mean, right?
Another nice vague word with no definition.
That's right. So it's not defined again in the statute, even though it's such a critical part of this exception. And so what courts would typically do in this case is they would look to the dictionary. And there are some dictionary definitions that suggest sort of a physical place, but there's enough broader definitions that don't seem to compel this to be a physical place, right? And it really is focused more on like the permanency or continued operation of the business. And so here again, I think that there's reasonable and potentially strong arguments that if you just take the word establishment and look at the dictionary definition, that even though the legislature here might have had in their head some sort of physical establishment, that there's no reason to discriminate between those companies that operate a physical establishment and those companies who have been in business for a long period of time, are highly established organizations, and that choose to operate and offer their goods for sale continuously through their online presence. It serves the same purpose. The physical establishment, frankly, doesn't serve any purpose, right? It doesn't make you less likely to be sending scam text messages because you have a storefront. Then if you have an online presence where, again, you're properly registered with the state, you have all these things in place, and you have established your permanency essentially in the marketplace.
Yeah, and I think that's another point is, to be clear, we don't know the answer to that. Nobody knows the answer right now, but logic and the legislative history would tend to, again, support the understanding that a retail establishment was put in there to say like, hey, look, if you're operating, we don't think that you're falling into this fly by night scam, unsolicited business. So um, I think it's to be tested. And unfortunately, I don't know that everyone would see it the same way we do, but I think it's a really strong argument.
Yeah, and I think it's fair to say, if I was back in my days of litigating as you are on outside counsel role, and I was litigating the first test case on this, I would 100% allege both of these
Oh
as
yeah,
affirmative defenses and try to present both of them. I wouldn't pick or choose one over the other at this
yeah,
point, particularly because you want the best opportunities. But both of these, to me, as a former litigator, strike me as very credible arguments, and that the real push would be around providing the court with enough context and understanding of why they should be interpreted in this way, what the original intent of the legislation was, and then what are the unintended consequences if you took these sort of lopsided or very narrow views of
yeah.
these terms.
I think that's right.
So we want to talk a little bit about enforcement, the other side of this.
So the Attorney General's office can bring an action in court for an injunction, and there's a $5,000 civil penalty. Excuse me. I think the bigger thing is that an individual can bring a claim under the Texas Deceptive Trade Practice Act, and that provides for the recovery of economic damages in certain circumstances. Although, and I think we get into this is what are economic damages, if a business has failed to register, and how would you go about proving that? So again, while this remedy exists, other than being fodder for the plaintiff's bar to hold businesses legally hostage, I don't know what the real economic damages are
Yeah.
here.
I think it's fair to say that we would anticipate that there will be claims brought under this act that seek damages under the Deceptive Trade Practices Act, but also try to assert that they're entitled to the $5,000 civil penalty. Plaintiffs will try to assert that you can multiply that $5,000 for each message, things of
Oh
that
yeah,
nature, in order to try to create the biggest leverage they can
yeah,
under this law. I think that's almost inevitably going to happen unless the law gets struck down or otherwise like fully clarified in a way that makes it clear that these exceptions do apply when you have consent, and that it's really going to be a matter of time, as we saw in Florida. I think your experience there kind of speaks to this, right? There will
yeah,
be litigation under this. Litigation may go in a number of different directions,
yeah,
and that ultimately, if necessary, then the resolution becomes going back to the legislature and saying, hey, you guys clearly didn't intend this, but here's how your law is playing out. And we need to be able to get clarification of the law as a result of that. We saw that in Florida, we saw it in Virginia, and ultimately, sometimes that's the path that the sort of full cycle this could take over time.
yeah. I absolutely agree. Just given the number of nuances, exemptions, and unintended consequences, my view is this bill needs to be drastically cleaned up. There's no, it's not really a way to operate in Texas for any type of business if you have to comply with all these requirements and the unknown. I mean, and I think what'll eventually, shake out is there'll be decisions, and they might not necessarily bring the level of clarity to each and every part of the bill that needs to be cleaned up. And I mean, and that's the great part about having a trade association such as the E-commerce Innovation Alliance, is that you can figure out who are the right people, to go speak and get that taken care of, or
That's right.
at least attempt to get it taken care of.
Okay, let's kind of move forward from chapter 302, the registration requirements, and jump into chapter 304, which is the other part of the law that does include text messages.
Yeah.
Do you want to
Sure.
take
So section 304 doesn't really make any substantive changes. I mean, you should already not interfere with the caller ID or cause misleading caller ID information to be displayed. So that doesn't change much. And again, if people are, using good business practices, you're not doing that anyway. I think the big change is that providing that a violation is a deceptive practice that can be enforced through the Texas Deceptive Trade Practices Act. And before that change, if you were on the Texas no-call list, only an individual had a path to seek damages. And then you had to file it first with the state agency and then give them 30 days to file a complaint. Now you just have a direct path, essentially a private right of action.
So it takes down some of the burden that might have kept individual plaintiffs that were on the do not call list from like pursuing damages under the act. It also broadens the private right of action. So instead of it just being about you were on the no call list, but you continued to receive calls, that it also, if there's issues around caller ID, then that's now also fair game for litigation that wasn't there before. So a couple of tweaks, a couple of changes in chapter 304. But again, the exceptions are really critical here. And so you want to chat a little bit about this exception under 304, established business relationship.
Sure. So you have the established business relationship exception. And that's kind of akin to the prior express consent under the federal TCPA, because it requires that two-way communication, not merely a sale. It just says an established business relationship means a relationship that is formed by a voluntary two-way communication between a person and a consumer, regardless of whether consideration is exchanged. And I think that's critical, obviously, because if somebody is on your website, has signed up to receive text messages, that section A is going to apply. Pertains to a consumer good or service offered by the person and has not been terminated by either party. So again, that would be the stop, the revoke, whatever language that they, opt out in a reasonable means. So the big takeaway here is if you're already TCPA compliant, you are not going to be subject to 304, and then you do not have to scrub the Texas do not call list.
Yeah, and I think just putting this in like broader context, right? Like here, the law is pretty clear, and it also is logical. And what I mean by that is the do not call list, whether it's the federal do not call list or the Texas specific do not call list, these are things where people put their phone numbers on to establish a default request to not call you. But once a person gives their consent and asks for the text messages, then clearly that consent should override their default preference to not receive marketing communications, right? And so if prior established business relationship was not an exception to the do not call list, then you would have to stop messaging a bunch of people that had asked to receive your messages, and that would be kind of crazy. And so here the law is just kind of confirming where we already stand on the federal level, which is, you don't scrub your opted in lists from text messaging against the federal do not call list or the state specific do not call list, because those are people who actually want to receive those messages. And so 304 for me is like a change, but one that shouldn't impact most merchants that are sending text messages.
Yeah, and I think this goes back to the good business practices again, right? Is that you're honoring opt-outs, you have your opt-ins. And, if you're doing those things, when somebody, even if they are on the do not call list, like you said, it expressly overrides the national or state do not call list, because they want to receive those text messages.
Sure. Excellent. So 304, pretty easy, much easier than chapter 302. And then let's talk just briefly about chapter 305, then the other one that is amended by SB 140.
Sure. So this is the automatic dialing announcing device. to mobile phones without prior consent if there's a charge for that specific call. I love that they don't define what an automatic, I can't even say it, it's a tongue twister, dialing announcing device is. I assume is that, are we thinking that's just like an automated dialer? Although
Considering how much litigation for so many years was
yeah,
focused on the comparable term under federal law, and that the definition, even though it was defined in federal law, went all the way to the Supreme Court
yeah,
to get clarity. The idea that this Texas statute governs this technology that is nowhere defined, to me, is just kind of like, you know, surprising that that has not received more attention. But
well, here it is for everyone. So section SB 140 amends chapter 305 by providing that a violation is a deceptive practice that can be enforced through the Texas Deceptive Trade Practices Act. And again, this provides an additional recovery of 500 per violation or 1,500 for willful violations. Again, if you have, my default is if you have consent, this, really shouldn't impact all that much.
that's right. And this was not amended to specifically include text messages. So even though they made amendments to move text messaging into the definitions on Chapter 302, text messaging were already part of the definitions of Chapter 304. The legislature did not see it necessary to amend Chapter 305 to include text messaging. So I think that there's sort of two different levels of analysis here. The first is probably a really strong argument that 305 doesn't even apply to text messaging because it's not included in the definitions. And then secondarily, if you're getting consent, then you're automatically outside of the bounds of what this is trying to regulate anyhow. So most merchants shouldn't have to worry about the fine details of what is an automatic dialing and announcing device, because that issue should never be relevant for them when you're sending messages based on consent.
I think that's right. And even though it doesn't define consent, I think there's a very good body of case law at this point that consent is, sufficient through a means where the consumer, that is clear and conspicuous that the consumer opted in to receive text messages. There's, whether it's through the TCPA, the FTSA, or other state law analogs, check boxes are always fine. Replying yes are fine. Again, there's often specific considerations. Was the text prominent enough? Was it before the sale, or not before? Was the disclosure, before you clicked yes? Was the box unclear? Things like that. But generally, as long as you're following clear and conspicuous disclosures for consent, it should be applicable, even though the statute does not define consent at this point.
Right. Okay. So that actually takes us through the entirety of the law, the changes that were made at Texas SB 140. But Alexis, I think we also want to kind of let people know about our plans for the Ecommerce Innovation Alliance. And because we understand and appreciate that the lack of certainty, considering the potential risk of litigation, is something that is not a place brands like to be, not a place customers like to be. They don't want to be, as one of the questions in the chat says, they don't want to be the test case for this. So the E-commerce Innovation Alliance, and part of the efforts that we've made over the course of the past week or so to make sure all PostScript customers are members of the E-commerce Innovation Alliance, is because we are preparing to challenge the law, likely in the courts, unless we get some resolution of it before we actually have to initiate the litigation. But we're planning to challenge the law based on its implications for the First Amendment, which does protect commercial speech. And in this case, it's clear, to me at least, that the law was not intended to have consequences on brands that are getting prior express written consent. Yet the lack of clarity or specificity in the law creates these potential burdens for companies. And so we're working diligently with Alexis and the team there at Bradley to prepare the litigation. We anticipate that it'll be filed in the relatively near term. We doesn't necessarily mean we're going to have clarity or resolution of this before September 1st. It'll take a while to work its way through the courts. But our goal here is to create this challenge and try to get ahead of this issue before a plaintiff's attorney brings a case and creates bad precedent or bad law. We think that helping the courts understand the full context and scope of the issue and its implications for law-abiding companies will help the court to reach the right resolution. And ultimately, if not, it will give us the clarity that people need then to understand that they have to undertake these burdensome requirements and to proceed in that manner. So that's our current expectation. We'll be providing updates as we move forward to EIA members, letting them know the status of the filings and things of that nature. But that's really at this point, I think the best that we can do as an association to try to bring clarity to companies on this issue and to try to help everyone get to the place in which they have the certainty that we would all like to have on something like this.
Yeah, and just one other thought. Well, I think bringing the affirmative motion, there's a host of issues that David and I have pointed out in terms of the vagueness and overbreadth and First Amendment issues. I think another thing to keep in mind as well is keep your terms and conditions. And I know Postscript has a set that are thoroughly vetted, but you can limit some exposure, although not all exposure. You can by just making sure your terms and conditions on your website are up to date. They limit class action exposure and have other mechanisms in there, preferably, whether it's an arbitration, which, depends on your own views, but other ways to kind of limit the potential for class action exposure while this works its way through the court system.
Yep. Great. There are a number of questions in chat, many of which relate to specific circumstances of specific companies and which are seeking specific guidance on whether they should or shouldn't register or certain fact patterns. It is important, as I reiterated at the beginning of the webinar, that we're not able to provide specific legal advice to individual companies on their facts and circumstances. You should consider engaging Alexis and working through either her or another attorney that can provide specific advice for your brands. Unfortunately, this isn't something that we can give definitive guidance on. Each company is going to have to make some individualized assessment of the cost benefit analysis of the registration process versus their feelings on the strengths of the defenses, the affirmative defenses. As we've said here, and I'll reiterate, we feel like those affirmative exceptions to these rules, both the customer exception and the established business should be strong arguments in any type of litigation that would occur under this. But because those arguments have yet to be tested, there's not a way to definitively tell how the outcome of those arguments will be if the case is tested in court. So ultimately, those are decisions that each brand is going to have to make with their team about whether to go ahead and go down the registration process and then appreciate all the complexity that would come with that type of disclosures within the text messaging campaigns. And if you're going to try to comply with that, or whether to feel comfortable that there would be these strong arguments if there was a challenge about whether you needed to register.
Yeah. There's no one size fits all approach, I think, is the answer here. And, I think we've laid out, there's a lot of gray still. And so did we want to try and tackle any of the questions? I know there's a lot of specifics to individuals. I think the first one we could probably, the digital marketing agency. David, do you want to, because I know we've been looking at the one of the exceptions, if 75% of your clients are accepted, then you too would have an exception is one of the exemptions, if that wasn't super confusing.
Yeah, that's right. So one of the exceptions that we didn't specifically address because it's not applicable broadly to those that are on the webinar is an exception that says if 75% of your customers that you're in contract with are subject to an exception from the registration requirements, then you are also not required to register. So that again would be an assessment of whether if you're sending messages on to individuals who have consented, then are those that are in your digital marketing agency customer list therefore accepted in there, and as a result of that, you as an agency would not have to register. So that it all kind of is intertwined essentially with the two exceptions that we've already discussed previously.
I looked at a bunch of the other questions real quick, which I think we've already answered in the sense that we can't give legal advice, at this point. There's there's a gray area, obviously, for whether the customer applies to people who have just perused your website and opted in through a double opt-in versus actual customer plus the retail business establishment. Whether you decide to register, that is a choice you need to make in context of your business risk tolerance, as well as if you want to consult, with an attorney. I did see one question on here, which is, I think did I put it up there? I'm not as good with it. It was the one on businesses. Where did it go? Oh, there it is. Would it be possible to circumvent these rules by adding a disclaimer to SMS opt-ins that mention SMS communications? No. And I actually thought about this too in terms of whether you could also just say, screw it, I am not going to message anybody in Texas. You could certainly decide, and I know businesses have done this for Florida while the FTSA was, working its way out, is to turn off all text messaging to anyone with a Texas area code. The only problem is that would not cover everyone because you have people who live in Texas who may not have a Texas area code. So they would still be a resident of Texas. The flip side of that is you may be losing a market of people who have a Texas area code, but have now moved to, some other state, Florida, wherever. But it's certainly, if that is a concern, you could certainly turn off text messaging to known people with a Texas area code. I will say I have had some clients, and it depends on your business, who turned off text messaging for Florida, not based on the area code, but some services actually have an address inputted for where like a service needs to show up for. If you know that it is like a Texas a Texas residence, for example, you could, I don't know how you would do it, but you can make the decision that we're going to opt them out of text messages unless it's, like an appointment reminder or some other kind of non-solicitation text message.
Yeah, keeping in mind that for many brands, Texas is a sizable part of their market.
Yeah.
We're certainly not recommending that people sort of try to siphon off Texas area codes because of the, as you mentioned, the inclusivity and the under inclusivity, and the fact that the people who are going to test this law candidly are not your average everyday people who are good actors. The people that are going to test this law are going to be those who are serial plaintiffs who are trying to manipulate the law. Those people are smart enough to know that they can go get a phone number from another area and if they're in Texas, sort of say they're a Texas resident. And so the abusive litigation that is like anticipated to come with any type of legal change like this is not going to be like stopped by stopping to message the 99.99% of people who actually live in Texas and definitely want to receive these messages and would never think about suing the brand. It's just not going to stop the bad actors who are going to try to exploit the law. And so for that reason, we're not encouraging people to try to like go about carving out Texas from this. We think that the reasonable approach is really to understand that there will be some litigation around this. That's why EIA is taking the lead and kind of going out and trying to get the clarity before any of the other sort of those that would try to manipulate the law get to the courts and create a bad record on this. We have an opportunity, I think, to kind of chart the course for this. Unfortunately, though, there's not a silver bullet on these types of issues where you can de-risk it entirely when it's really the bad actors who are going to be the ones manipulating it.
And there's always going to be, like when the FTSA went into effect in 2021, you had a whole host of firms who were lined up and ready to go with, brothers, sisters, aunts, uncles, who were the plaintiffs. So those are always the people that are most ready to take advantage of the statutes. Saw another one on here. Best way to make sure terms and conditions protect against class action exposure. Did we want to talk about that one a little bit? Because I know Postscript does a great job of incorporating those into their terms and conditions. I don't, if you are not using Postscript's terms, which I understand are, and David, you can explain this better than me, but it is a recommended feature, but it is not one that is required. You can use your own terms and conditions. I think there's an inherent risk if you've created your own terms and conditions that have not been vetted to your specific company with a mind towards decreasing class action exposure. There's a certain checklist of requirements, that you want to make sure you have. I'm not going to go into all of them now, but essentially, courts are reluctant to find that a consumer has waived their right to their day in court unless the terms are clear and conspicuous. There's a variety of ways that you can do that in your terms and conditions: bolding, headings, making sure they're aware at the front of the page, clear opt-ins. But so if you're not using Postscript's terms and conditions and you don't have an attorney that has vetted yours, I highly recommend you reach out to your trusted legal advisor to make sure that you have terms and conditions that can protect against class action exposure.
Yeah, I think that's right. The service for Postscript is called the dynamic terms of service, and it's a feature that can be activated or deactivated in the platform. Really critical, and sometimes I see brands get this wrong. Like if you activate it, but then don't have the right links being used in your your checkout page on your Shopify site that's not controlled by Postscript, then you're not getting the full advantage of having the dynamic terms of service. And so one of the things I would definitely recommend for any Postscript customers is just to do an audit of all of your collection points and make sure that whether you're using the dynamic terms of service or your outside counsel or in-house attorneys have provided something that they consider to be up to date and up to speed on all the legal changes that continue to happen in this space, that then you're using the right links consistently and that at every opt-in point, so there's not this disparity about who is actually consenting to what terms. The other thing I would say is there is recent case law about how to display the terms at the point of opt-in, specifically that people are agreeing to the terms, not just viewing the terms, but they're saying, I agree to these terms, and that the terms of service that are hyperlinked are capitalized and bold and different font colors so that people really can't say, oh, I didn't realize I needed to click on the link to go read the terms. I think those tips and those sort of very practical things, and there's help desk articles and other support on that, are really critical ways to help mitigate risk in this environment, and that are good practices, not just for Texas, but really across the country.
It looks like we've reached our time for today.
Great. Well, thank you, Alexis. I really appreciate you joining us for the conversation. Thanks to everyone who joined as well for today's webinar. If you have specific follow-up questions after today's webinar, you can email them to me. I'll respond to them to the extent that I'm able to. Again, if you're asking for specific advice about your company and how you should react, I'm not able to respond to those questions. But you could reach out to Alexis to pursue a potential engagement or to another attorney that has experience in this space. Thanks again for your time, and appreciate you being here, Alexis. Take care.
Thank you, and thanks for having me.